Half a day. Half a day. The Committee on Justice is now called to order. Today is Wednesday, June 23, 2021, and the time is 5 p.m. Notices for this informational briefing were disseminated via email to all senators and all main media broadcasting outlets on Wednesday, June 16, and Monday, June 21, 2021. The notice was also published in the Guam Daily Post on Wednesday, June 16, and Monday, June 21, 2021, and in the Pacific Daily News on June 15, 2021. This hearing is hosted by the Guam Legislature's staff and my committee staff. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. After presentation from those who are the panel that we have invited, we will allow questions from the senators. We will ask senators to pose 1 or 2 questions on the first round, and then we will follow up with additional rounds if necessary. I'd like to acknowledge the presence of my colleagues with me today here, beginning with the Vice Speaker, Senator Tina Muñoz-Barnes, our Legislative Secretary, Senator Amanda Shelton, co-sponsors of the bill who are here with me, Senator Terlaje, Senator Joseph Augustine, Senator Joanne Brown, Senator Anthony Ada, and Minority Leader Senator Chris Duenas. Today's informational hearing will feature an introduction of Bill number 1112-36 and a comparison with the current medical malpractice mandatory arbitration law, also known as MMMA, provided by the prime sponsor of the bill, who is myself, and a couple members of the Guam Bar Association, and members of the malpractice insurance industry. As a reminder, public testimony on the bill will be accepted at the public hearing set for July 7th and July 12th at 5 p.m. We highly encourage input from the community, and we ask you to please contact my office to register so that we can sign you up to provide testimony. I'd like to clarify that no official opinion of the Guam Bar Association Board of Governors has been received, and that the members of the Guam Bar Association here are, as I am, individual members of that association by mandate of law. Public hearings on Bill 112, again, will take place on Wednesday and Monday, July 7 and July 12 at 5 p.m. to 8:30 p.m. And I've invited medical professionals and the public to participate and to submit written testimony at any time prior to those hearings. You can call my office at 472-3586 or email Senator Terlaje Guam at gmail.com, hopefully by July 6th, in order to register. We will try to accommodate both in-person and Zoom testimonies as much as possible. All documents submitted relative to Bill 112-36 are going to be made available and are being made available at www.senatorterlaje.com. All hearings will be broadcast on GTA TV Channel 21, Docomo Channel 117, or 112.4, and via the Guam Legislature's Media's YouTube. And they will be available on the Guam Legislature Media's YouTube channel after the hearings. Bill number 112-36 COR is introduced by myself, Speaker Therese M. Terlaje, Senator Tello T. Taitagui, Senator Joanne Brown, Senator Tina Rose Muñoz-Barnes, Senator Joe S. San Augustine, Senator V. Anthony Ada, Senator Talina C. Nelson, Senator Christopher M. Duenas, Senator Clinton E. Rigel, Senator Amanda L. Shelton, Senator Jose P. Terlaje, and Senator Sabina F. Perez. I'd like to note for the record that Senator Tina Rose Muir-Barnes has sent me a letter prior to this hearing, just minutes prior, asking to be removed as a sponsor. Bill 112-36 COR is an act to add a new Chapter 10 to Division 1, Title 10, Guam Code Annotated, to add a new Section 42A101 I-20 to Chapter 42A of Division 3, Title 7, Guam Code Annotated, to amend Section 42A101J of Chapter 42A, Division 3, Title 7, Guam Code Annotated, and to repeal Chapter 10 of Division 1, Title 10, Guam Code Annotated, all relative to medical malpractice in the territory of Guam. This bill was introduced after numerous informational hearings on the current mandatory malpractice arbitration law that took place last term, after oversights of the medical licensing boards and other health boards, and careful review of NCSL's analysis of malpractice laws in other jurisdictions. In drafting the bill, we looked at a way to mitigate the cost of arbitration in order to remove a huge barrier for working class and indigent patients who currently can't afford the estimated $50,000 needed for arbitration fees, filing fees, and arbitrators' fees and other costs, and the other $50,000 if they proceed to trial beyond arbitration. So this bill is intended for these individuals and these families with legitimate injury due to negligence who are being denied justice due to costs. Bill 112 does not make patients win in these cases. It gives them no preference. It simply allows them to seek justice through the legal system like everyone else. This bill puts poor patients on the same level as rich and VIP patients in demanding standard of care and recovering from injury due to negligence, not more and not less. Bill 112 continues the current policy in Guam law of providing a screening process to protect doctors from frivolous lawsuits. The screening process can be arbitration, as agreed by the parties, mediation, or if no agreement otherwise, then the case will be screened by a magistrate judge before it is allowed to go to a trial with a jury. There is a misconception that we are removing the screen altogether and that claims would go straight to trial, as all other negligence cases do. A magistrate is less expensive screening panel than the 3-member arbitration panel's screening cases that estimate $450 to $850 an hour per arbitrator. And Bill 112 provides further protection for doctors in ensuring confidentiality of claims made against the doctors until they are completely screened, and unlimited confidentiality upon agreement of the parties. The proposed legislation would only apply to those healing arts professions covered under the current Medical Malpractice Mandatory Arbitration Act. No changes are being proposed as to who is covered. The proposed legislation applies the exact same standard of care as the current law. What is allowable medicine today is allowable if this bill is passed. Claims can only be brought if there is negligence, if the action falls below the standard of care. These instances are extremely rare, according to the testimony that we have received in the 3 prior informational briefings on this topic. The standard of care in a malpractice suit is normally established by expert testimony before the arbitration panel, and again before the jury. Bill 112 allows expert testimony and other testimony to be provided to the magistrate as well, by both sides in the same way that evidence of the applicable standard of care is presented to judges and juries. The bill does not affect the Government Claims Act, which sets different liability for all government agencies and employees, including government health care providers and specialists working at GMH. Nothing in this bill should therefore affect the provision of services in the ER or those practitioners currently consulting with or working for government hospitals or the Department of Public Health. Bill number 112-36 is meant to ensure medical malpractice complaints are properly reviewed in arbitration, mediation, or by a magistrate before moving forward through the court system, while also considering a patient's right to due process when they are unable to afford initiating the arbitration process. The options that are available today to deter bad doctors and deter substandard care for patients under current law are a barrier. For a patient or a family member of a patient on Guam who has suffered an injury or death due to medical treatment that was allegedly below the substandard, the accepted standard of care. Claims of medical malpractice, so under the current law, claims of medical malpractice must go through a mandatory arbitration process before having the option to be heard in court. It's a private process where disputing parties agree to one or several individuals to arbitrate their dispute, depending on the company that they go with. Arbitration filed with the American Arbitration Association requires a $10,000 filing fee, and they normally select a pool of a 3-person panel of arbitrators, 1 lawyer, 1 doctor, 1 community member. This panel is tasked with hearing the merits of the case, hearing from the expert witnesses, and rendering a decision and an award. Claims can then be appealed to the Superior Court if the parties dispute the decision. Complaints against health professionals can be filed also through health professional licensing boards, which are authorized to evaluate allegations of misconduct and take actions against the licensee, which may include public reprimand, imposing a fine, ordering probation, restricting the license or certification, suspending the license or certification, revoking the license or certification, or dismissing the complaint. Licensing boards do not grant monetary relief for damages. On September 2019, the first hearing was held in the last term to present senators and the public with a basic background of the malpractice law and prior cases interpreting the law. The Office of the Attorney General briefly discussed and distinguished the law governing claims against the government and government health professionals. Attorney Mitch Thompson, who represents several providers, including the Seventh-day Adventist Clinic, presented an overview of Guam's Mandatory Malpractice Arbitration Act and a few relevant past cases. Members of the Guam Bar Association also presented an examination of the current law. On October 3rd, 2019, the second hearing was held with health professionals to focus on the impacts of the current law on their practice, on whether the law ensures the appropriate standard of care on Guam, and the impacts of the law on the availability of qualified health professionals. The heads of the Guam Medical Association and Guam Medical Society led the health professionals panels. On November 7, 2019, the third and final hearing was held to hear the suggestions for reform or arguments against reform from legal and health professionals and the public. Patients and their families and the general public were given the opportunity at all 3 hearings to provide comments. The committee found that costs of arbitration can average between $40,000 to $60,000 upfront per party, that the high cost of arbitration services have deterred claimants from seeking justice or compensation on potential malpractice cases, and that over the last 5 years, there had only been 3 cases that had gone through the mandatory arbitration process. And this number may have gone up to 7 cases if we counted the number of cases that decided not to go forward with the arbitration process. During the hearings, leaders and practitioners in the medical field testified in opposition to any repeal of the law based on the arguments that a repeal would open the floodgates to frivolous litigation, would cause doctors to practice defensive medicine and refuse to provide care outside of their specialty. It would increase the cost of malpractice insurance premiums and practice on Guam. They also testified that it would worsen the healthcare shortage on Guam, negatively impact the recruitment and retention of medical professionals on island, and lead to a record that claims would lead to a record on the National Practitioner Data Bank, hurting chances for future employment. They had recommended that licensing fees and taxpayer money be used to assist claimants with the cost of arbitration. Some of them had recommended that. Members of the public whose family members were patients or who were patients themselves and suffered some alleged malpractice recommended a repeal of the current law and implementation of alternative process that was more affordable, less biased, equitable to the review of claims. Some of those recommendations included the implementation of screening panels for the review and determination of malpractice claims for a liability that is non-binding, implementation of screening panels to determine damages, and for panel findings to be admissible in court. Some recommended that mediation be an option, and some recommended all-out repeal of any screening panel. On June 29, 2020, the Committee on Health held an oversight hearing with the Department of Public Health's Professional Licensing Office with emphasis on the Guam Board of Allied Health Examiners and the Guam Board of Medical Examiners to receive updates on the processing and investigation of complaints submitted to the boards between 2018 to 2020, amongst other compliance issues. This hearing was held following numerous concerns from claimants that cases were not being handled fairly or in a timely manner. The committee found that between 2018 to 2020, the Guam Board of Medical Examiners received a total of 24 complaints. All were either investigated or in the process of being investigated by the board, with 22 resulting in findings of no violations by the board, 1 complaint withdrawal, and 1 pending at the time. None of the complaints had a hearing with a hearing officer. Between 2018 to 2020, the Guam Board of Allied Health Examiners received a total of 14 complaints. 1 was reported to the National Practitioners Data Bank, 2 resulted in a finding of no violation by the board, and 11 were still pending investigation at the time of our hearing. Bill 112 was introduced after careful consideration of all the concerns expressed, research of the processes implemented in other jurisdictions, and most importantly, with heavy consideration given to the serious concerns of the doctors and barriers to redress the barriers, to claimants who were seeking justice that the current law was denying them. And challenges with the complaint and investigation process of the licensing board. As the chairperson of the Committee on Health, I've invited 2 attorneys here today, Attorney Mitch Thompson and Attorney Robert Keogh, who are both members of the Guam Bar Association, to provide a comparison of current law and Bill 112-36 from a legal perspective. Attorney Thompson presented an overview of current law and prior year outcomes at the informational briefing discussed earlier, and this presentation is available at the 35th Guam Legislature's website under Hearing Reports in the first informational briefing on Guam Medical Malpractice Mandatory Arbitration Act, which is also available on my website at senatorterlaje.com. I want to thank Attorney Thompson for joining us today and allow him to please proceed with your presentation. If you could turn your microphone, yeah, thank you.
Madam Speaker, I'd like to thank you for this opportunity to testify this afternoon. Committee members, again, thank you. Okay, it's a little hard with the mask. I have to get used to how close to put the microphone. So I just want to make clear that this afternoon I am speaking as a member of the public, a concerned citizen. I'm not here representing any entity or anybody except for myself. So it seems to me that the concern about the current law is the cost and the concern that indigent people may not have the means to pursue what may be valid claims. For the reasons I'm going to set out, I believe that Bill 112, as currently written, is not the answer to this perceived problem. Currently, under the arbitration law, as I'll refer to it, the panel that determines the claim consists of one healthcare provider, one lawyer, and one person who's none of the above. Typically, that third person, from my experience, has been another professional, an accountant, an engineer, an architect, someone like that. And I think the purpose behind having at least one healthcare provider on the panel is to assist and have someone with expertise in medical issues as part of the panel so they can collaborate and hopefully reach the correct result. My concern with the proposed bill is that there's no panel, there's no collaborative effort amongst people with different backgrounds and experience. Instead, it's one person, a magistrate judge. Now, meaning no disrespect to our magistrate judges here, but as far as I'm aware, none of them have any particular medical training or medical experience. So I think when the screening panel as proposed here doesn't have a healthcare professional on it, it kind of defeats the purpose, because I think we would want someone with that kind of training and background to make up part of the panel. Now, I can't say that I have done exhaustive research on every single state, but in the limited time I had to look into the matter, based on what I was able to find online, it appears that most states that have screening panels typically have at least one healthcare provider as part of the panel. Some states have more, some states have 3. I think Utah has 5. And I think the purpose behind that is to have people with experience, training in healthcare issues. The idea is that they would be in a better position to determine whether or not this claim has merit. I would note that under Guam law, the body that determines complaints against doctors, the Guam Board of Medical Examiners, it's made up of physicians. Similarly, if you make a complaint against a dentist, it goes to the Guam Board of Dental Examiners. The Guam Board of Dental Examiners is made up of dentists. And it makes sense because they have the training and the experience to evaluate the complaint. So I think that that's a major failing with the proposed bill, is that there is no healthcare provider as part of the screening panel. A second concern I have is that under the current law, if the party who loses at arbitration decides they want a do-over, a trial de novo in front of a jury, there's a catch. If they lose in front of the jury, they have to pay the other side's attorney's fees and expert witness fees. And medical malpractice cases tend to be expensive because you have to have expert witnesses, typically specialists or physicians, and they generally don't work cheap. This is a real deterrent for people who lose in front of the arbitration panel to say, well, I don't care, I want to roll the dice in front of a jury. There's a risk there because if they lose again, they could be out a lot of money. They have to pay the other side's legal fees and expert witness fees. And again, I can't say that this is 100% correct, but as best I can tell, in the roughly 30 years that the current law has been in effect, there has been one trial de novo following an arbitration award. One. So I think the current law deters the loser in front of the arbitration panel from demanding a do-over in front of a jury. Well, let's compare that with the proposal in Bill 112. There's no consequences. There's no financial consequences under the proposed bill. If you lose in front of the magistrate judge and you say, well, I don't care, I want a jury trial anyway, you don't have to pay the other side's legal fees or expert witness fees. There's no financial disincentive to not roll the dice. And I think that's a major failing with this proposed bill. Under Bill 112, there is an exception so that if your claim is less than $20,000, you don't even have to see the magistrate judge. You can go straight to trial. That's unlike the current law. Under the arbitration law, there's no small claims exception. Well, why is that an issue? Well, insurance companies, when they look at a claim of $20,000, they typically analyze it this way. Well, how much is it going to cost us to defend this claim? And even if the claim is really a nuisance claim, the insurer may well decide, well, if it's going to cost me $10,000 or $15,000 to defend a $20,000 claim, we might as well just give them some money and hope they go away. And of course, it's even worse if you're a provider and you don't have insurance, because then you're looking at, well, this person is suing me for $19,000 and it's going to cost me $20,000 to defend the claim. I might as well just pay it, because otherwise I'm going to end up spending more money just to defend the claim. So I think that's another problem with the bill. This small claims exception, it's going to cause problems, I think. And there's absolutely no disincentive now. There's no screening as far as whether the claim has any merit or not. There's absolutely no disincentive to not file a small claims case. I would note that there has been, I've seen some complaints about the current law to the effect that, well, Guam is the only place that has this type of law. We should, be more like other jurisdictions. Well, to the extent that that's an argument, most jurisdictions have caps or limits on the amount of damages that can be recovered. And I think that that is intended to reduce the chance that a claim in front of a jury becomes a lottery ticket. In other words, we want to even out the potential award in such cases. And without caps, the sky is the limit. And Guam is in the minority in not having any caps. And so I think if the legislature is looking at bringing our medical malpractice law more in line with the rest of the country, then caps on non-economic damages should be part of the consideration. So, if Bill 112 is not the answer to the question as far as how do we make sure that indigent people can pursue potentially valid claims, I think the answer was discussed in today's PDN. I don't know if everyone saw the editorial in today's PDN, but, and I think it was very well done, but the editor said, look, if the issue is, and our concern is that poor people don't have the ability to pursue claims because of lack of financial resources, a bill was submitted in the last legislature by Vice Speaker Munya Barnes, which would address that issue. In effect, it set up a revolving fund so that if somebody had a potentially meritorious claim, but they didn't have the financial ability to pursue it, they could apply to again, I'll just refer to it as the revolving fund. If the claim was thought to have potential merit, the fund would advance the costs. If the claimant won, he or she would have to reimburse the fund. If the claimant lost, well, I guess we're all out. And I think if the concern is that fund as initially proposed was not large enough, let's make it bigger. The government has received a lot of money from Uncle Sam for health-related issues in the past few months. And so it seems like there should be a way to get this revolving fund started. And I think the editorial in today's PDN sums it up pretty well, is that the bill that was proposed by Vice Speaker Munya Barnes would specifically address this problem, and we don't need to throw the baby out with the bathwater. If the issue is indigent people may not be able to afford the cost of arbitration, let's fix that. I'd ask the legislature to take a look at the bill proposed by Vice Speaker Munya Barnes, and if it needs tinkering, let's tinker with it. But that's the way to enable people who may not have the financial resources to pursue their claim. And I'd be happy to answer any questions that the committee members may have.
Thank you, Attorney Thompson. I intended to mention before any of you testified that I have asked, just one second, that I had asked everyone, and I am asking everyone who's going to sign up to testify in any of the hearings on this bill that they are aware of the lobbying statute 2 GCA 8101, which requires paid lobbyists to register with the legislative secretary. Thank you. And if I could ask, and Attorney Thompson, I'm sorry, could you just state for the record, I know that in previous hearings you had represented that you represent the SDA. If you could represent today, we just received a letter from SDA claiming it's going to turn patients away now from specialty care, but if you could just clarify who it is that you're representing today.
Well, I'm here as a member of the public and a concerned citizen. My testimony and my opinions today are my own.
Thank you. Attorney Keogh. Attorney Keogh was also present at previous informational briefings of the committee and had provided in previous testimonies that he represented patients bringing claims and also doctors in this medical arbitration experience, and that his experience, we did note his experience in also compiling this bill. Mr. Keogh, if you could please proceed.
Thank you, Madam Speaker. I have submitted written testimony, and I'm not going to reread that testimony here today. What I would like to do is perhaps do three things. One, describe some of my own personal experience with medical malpractice cases. Do a little bit of comparison of the current law with the Bill 112, although Senator Terlaje, you've done pretty much of that already. I think that's well understood. And then express some of the concerns that have been submitted in comments by doctors and some of the comments from Mr. Thompson just now. I would like to say if anyone wishes to interrupt me while I'm speaking and ask a question, I'm perfectly open to that. Judges do that to lawyers all the time. I've been in private practice on Guam for 40 years. I came out here originally in 1977 with a federally funded legal services program, and then in 1981 started my own private practice of law specializing in plaintiffs' personal injury cases. I've recently engaged in an examination of my records of cases for the last 24 years from 1997, which is the only time limit the time from which I started keeping these records. And out of a total of 1,242 cases that my office has handled, I have handled 23 medical malpractice cases. That's less than 0.02% of my cases. 6 of those 23 cases were government claims not covered by the arbitration law. 7 of them were settled without arbitration. 5 of them were withdrawn for various reasons by the clients, and 5 have proceeded to arbitration. Only one, as Mr. Thompson commented, only one of those, in my experience, ever proceeded with a trial de novo to court. These statistics emphasize what, Madam Speaker, you said previously, medical malpractice cases are extremely rare. There is a number of reasons for that. One of them, of course, is the cost of doing arbitration under this current arbitration law. Another is that medical malpractice cases are inherently expensive because you do need to hire an expert to give you an opinion as to whether or not treatment was below the standard of care. Under the current law, any plaintiff, any person who perceives themselves as being a victim of medical malpractice must go to private arbitration before they can proceed to court. That arbitration requires the hiring of an agency, such as the American Arbitration Association, who charges administrative fees. In one case that I'm going to give you an example of, their fee was $10,000 just to file their case. Then you have to pay 3 arbitrators. Arbitrators charge $450 or more per hour to deliberate on your case and to handle pre-trial procedures. Each party must pay 1/2 of these anticipated costs in advance of being able to proceed with arbitration. After a trial, either party may appeal for a trial de novo, but there are those penalties that Mr. Thompson discussed. One element of the current arbitration law, which is addressed by the new law, is that there is no confidentiality requirement in the current arbitration law. There is nothing in that statute to stop anyone from going to the press or discussing their case in public, or even sharing the pleadings with members of the public. That has been changed in the Bill 112. I'd like to give an example of a case, one of the cases that I took all the way through arbitration to an award. In this case, a gentleman, a real live person who had a bad outcome from an experience at a medical facility here on Guam. He suffered a ruptured disc in his lower spine. The local clinic misdiagnosed his condition, which resulted in permanent partial paralysis from the waist down. Before even proceeding, we obtained an opinion from a board-certified urgent care physician that stated that that misdiagnosis fell below the standard of care and was the cause of his paralysis. The case was not able to be settled, and it went to arbitration. It went through the American Arbitration Association. There were 3 arbitrators, a local lawyer, a local non-lawyer, non-doctor, and then a doctor from Hawaii. The fees charged by the American Arbitration Association for that case after trial amounted to $47,000 for the plaintiff's share alone. The defendants had to pay the same share. These expenses did not include other expenses such as the fees of the expert witness, deposition costs, travel costs that were involved in obtaining some testimony. In the end, this particular plaintiff received an award of over $1,350,000. This plaintiff could afford the arbitration costs, and his case was obviously worth proceeding. Neither party appealed the case, the award of the arbitrators for a trial de novo, and the award was paid. But this just underlines and emphasizes that arbitration under the current law is so excessively expensive as to render arbitration or proceeding on a malpractice claim unavailable to the majority of people. You don't have to be poor to not be able to afford $47,000 just for the cost of having an arbitrator or a judge hear your case. Under Bill 112, a medical malpractice case can indeed be filed in court. You don't have to go to arbitration. You don't have to pay for private arbitrators to hear your case. But once filed, the case is immediately sealed and kept confidential. The case is assigned to a magistrate judge, and the magistrate judge is to decide, does the case have merit? That is, was there medical malpractice? And if so, did the medical malpractice cause injury to the plaintiff? And if so, to award damages. Each party, either party, the plaintiff or the defendant, could appeal to a court for either a judge trial or a jury trial at their choice. If that case is appealed after the magistrate's decision, the magistrate judge's decision is admissible as evidence at that trial. That is clearly a disincentive to appeal. If you're unhappy with what the magistrate judge decided, you're going to know that if you go in front of a jury, that decision from that magistrate judge is going to be read to the jury, and they're going to hear that a judge has already determined your case to be without merit. There is no cost to either party for proceeding with filing a case in court under Bill 112, except for the filing fee in court of approximately $250. And even in that case, if you are truly indigent, there are informa pauperis procedures in both the local and the federal courts to exempt you from having to pay for a filing fee. There's no need to pay 3 arbitrators at $450 an hour or more to hear your case. The magistrate judge is a salaried government employee. The magistrate judge is an experienced judge familiar with the laws of evidence and familiar with the concept of standard of care. A judge will listen to the opinions of experts. Both sides will present experts, and that's to inform the judge of their opinions of whether or not there was malpractice and why or why not. The judge will listen to those opinions from both sides and make an informed decision. That is what judges do every day in courts here and everywhere throughout our country. They listen to witnesses, to opinions, they weigh the facts and the opinions, and they make informed decisions. That's what judges do. The Bill 112 also provides that if parties decide they want to use arbitration or they want to go to mediation, for example, they're free to do that. It's not compelled. If, for example, a plaintiff brings their claim and the defendant doctor says, well, let's do arbitration, and the plaintiff says, I can't afford it, and the doctor says, I'll pay for it. I have a case like that right now. We agreed. If you're going to pay for it, we'll do it. That's an option that's available in this bill, and it is something that is done by agreement, not forced upon you by statute. The process in Bill 112 is designed to weed out frivolous cases or non-meritorious claims and to encourage settlement. Medical malpractice cases, they involve real people with real, often tragic outcomes. However, a bad outcome from a medical procedure does not necessarily mean there was malpractice. A bad outcome has to have been caused by treatment that a medical expert will give an opinion that says was below the standard of care, below what was expected of the physician in his or her field. This Bill 112 retains the community standard of the community definition of standard of care. That means the standard of care of a physician practicing here on Guam is what is expected of a physician practicing here on Guam. If a doctor does not have specialized expertise and treats the patient the best as that physician can under the circumstances, that is not medical malpractice under a community standard of care. The way that the concerns that many of the doctors have submitted about, well, we're going to have to stop referring cases to specialists, or if we don't have diagnostic equipment, we can't do treatment. There is a concept in Guam law called informed consent. Doctors must obtain informed consent from their patients before doing something. If a doctor informs the patient, well, I would advise you that you need specialized care, and if I were you and could afford it, I would go to the Philippines or I would go to Hawaii or somewhere else and get the treatment, and the patient makes the decision, no, I'd rather stay here with you, that's informed consent. And then as long as the doctor treats that patient within the best of his or her ability and expertise, no expert is going to give an opinion that that was below the standard of care. So Bill 112 is designed to distinguish bad outcomes from medical malpractice. Let me give you another example of a pending case right now of a mother who gave birth at a hospital. The hospital put an IV into the infant's hand. The infant was one of two twin girls born. 2 days later, that IV site became infected. The arm of the infant was red and swollen and hot all the way up to the elbow. The hospital staff removed the IV and put bacitracin on the wound, the same substance that you can buy at Rexall, just a store-bought antibiotic ointment. No intravenous antibiotics were given. 3 days later, that baby died of a massive MRSA infection and had systematic organ failure. MRSA is a antibiotic-resistant staph infection that is common in hospitals. A physician, a professor from the Keck School of Medicine at the University of Southern California, gave an opinion that said that treatment fell drastically below the standard of care, and that child should have survived and lived a long and healthy life. And instead, that mother is having to live with the loss of one of her two twins and is reminded of that every day as she continues to care for and raise the surviving twin. That mother happens to have family who can afford to help her with arbitration, and they are, and that case is in arbitration. We asked the Superior Court of Guam, in that case, to strike the current arbitration statute as being unconstitutional because it prohibits people such as this woman, from bringing claims that they cannot afford. Judge Senzon denied our request and said, this is a problem for the legislature to solve, not the courts. If this woman's family could not afford to help her with arbitration, she would be out of luck and her claim would never be able to be resolved. So that just points out that these cases involve real people with real events, real circumstances that are seriously and drastically impacted by the need to have to arbitrate with 3 arbitrators under the current arbitration law. Let me just quickly then say a few things about some of the comments I've seen in the medical field against this law. One is that this bill is being described as a get-rich scheme for lawyers. Now, how cynical is that? Medical malpractice cases, in the first place, are expensive to bring even without arbitration because of expert witness fees, discovery costs, and what have you. Plaintiffs' lawyers do usually work on these kinds of cases on a contingent fee, which means the lawyer takes a percentage of the recovery. The contingent fee has been regularly described as the poor person's key to the courthouse. If you have to pay a lawyer $250, $350 an hour to bring your case, most people are not going to be able to bring them. The contingent fee is what makes those claims capable of being brought. Contingent fees are applied in injury cases, automobile accident cases, all kinds of cases that will produce hopefully produce a recovery, and the lawyers take a percentage of the fee. The lawyers' fees on Guam are limited by statute to 10% of anything over $100,000. That's the law, 7 Guam Code Annotated 26601. This isn't a get-rich scheme for lawyers. This is hopefully a quest for justice for people who have received or are the victims of medical malpractice. A lawyer won't take a case in the hopes of getting a 10% fee if the case is a frivolous case. Plus, lawyers have ethical duties to the courts and to the public to not engage in such frivolous activities such as bringing a case that has absolutely no merit. Again, the purpose of Bill 112 is to weed out, if there is a possible frivolous claim, and only address viable, meritorious claims and hopefully encourage settlements of them. I've heard comments from some of the doctors that it's going to open the floodgates. There is no flood being held back by gates. As I explained in my statistics, 0.02% of my caseload over the last 24 years have been medical malpractice cases. It doesn't happen very often, but when it does, it can have tragic outcomes, tragic consequences for real live people. Comments have been made about this bill will encourage the filing of frivolous claims. Absolutely not. There is nothing in the current law to prevent the filing of frivolous claims other than the fact that it costs so much to go to arbitration. Frivolous claims are not the problem that this bill is intended to seek. It is the meritorious claims that can't be brought because of the expense that this bill is designed to aid and enhance. I find it curious that such comments as what was in the SDA letter that Speaker Terlaje just referred to is that they're going to stop doing certain services because of this, fear of being sued because of this bill. If you're doing those services now and you're afraid of being sued for them, then those services are malpractice. The only reason you're not being sued now is because it's too expensive to do it. A doctor shouldn't be doing services that constitute malpractice. Why would you stop doing something that you feel is right to do now just because now somebody can bring a claim? It is a very curious comment. Putting a doctor on the panel, first of all, this is not a screening panel. This is a process for a magistrate judge to screen the cases, but only after a full presentation of evidence. You can't put a doctor on that. Who's going to pay for the doctor? Are doctors really interested in sitting on panels here? I've never been able to get a local doctor to agree to sit on a malpractice panel here. And the local doctors invariably will be biased against any malpractice claim. Judges are trained to overcome, to not have biases, to overcome any kind of personal feelings on a case. They look at the evidence and they make a decision. And still, there's nothing to stop any individual from bringing a claim to one of the boards that Mr. Thompson referred to are staffed by doctors or dentists, if it's a dental board. There's nothing to stop them from doing that. You can bring that claim. Applying caps is another really serious problem. Let's say, for example, you have the classic malpractice circumstance where somebody was to have their leg amputated because of some kind of serious infection that couldn't be resolved, and the only way to save the person's life is to amputate the leg. The doctor goes into surgery and amputates the wrong leg, and then has to go back and obviously amputate the correct leg that's causing the infection. If you have a cap, that person's, let's say the cap is, as in many states, as some states have, I know California has a $250,000 cap for that. So that means that that person who has to live, let's say the person was only 18 years old, has to live the rest of his or her adult life with no legs, and the total compensation for that tragic mistake is $250,000? Does that really compensate the person for the pain and suffering that they're going to endure for their entire life because of that? Is that a fair outcome? No. Two things that I'd like to recommend that be included in the bill is to have some kind of monitoring reporting requirement that the courts report back to the legislature annually to show what the experience with the Bill 112 process is. If there really are floodgates that are open because of this, then the court can report to the legislature how many cases there have been, what the outcomes have been. If that really is a problem, then the legislature is capable of looking at it again and resolving the problem. Another solution would be to encourage the insurance industry on Guam to provide perhaps a high deductible medical malpractice insurance to doctors to spread the risk of malpractice across and throughout the entire community, rather than to place that risk on that burden and that risk on the backs of the few victims who actually experience medical malpractice. The small claims exemption that Mr. Thompson referred to, I know from what I've read in cases that there have been examples of extremely small claims, like claims against a veterinarian for injury to their pet, that under the current law still have to go through arbitration. Maybe it was only a $500 bill or a $1,000 claim, something small. it still has to go through this mandatory arbitration and potentially cost $40,000, $50,000 in arbitration fees to be able to have a small claim such as that. A small claims exemption makes entirely good sense to have. As far as having a fund as in the prior legislation, why do we need to have a fund to pay private arbitrators $47,000 to hear a case? And in the case that I described, one of them was a doctor from off island who had to be paid to come here to Guam and stay in a hotel, and some of those money had to be paid to the American Arbitration Association to administer the claim. Why have all of that process when we have magistrate judges already on salary, trained, experienced adjudicators to be able to listen to cases without having to pay private individuals to sit on their cases and decide them? That's really all I have to say. I'm happy to entertain any questions that may be asked.
Thank you, Attorney Keo. In an oversight of the Health Professional Licensing Office held on June 29, 2020, the Guam Board of Medical Examiners reported no reports of final judgments, settlements, or awards against insured licensees from malpractice insurance carriers. And none had been reported from the licensees themselves. So I've asked, we were, as a committee, unable to obtain information as to how many persons or providers on Guam are covered by insurance, how many are not, and what the cost of those insurance is for these providers. And so I'm asked these providers to present testimony, and we'll now hear from Mr. Vic Polino from Cassidy's Insurance. And we sent questions in advance to guide this discussion to Mr. Polino, similar to what I've just stated. And so, Mr. Polino, if you could, you're welcome to make whatever presentation you would like.
Afadi, Madam Speaker. Thank you for allowing us to provide information and input during this hearing. I thought that we're just going to be addressed questions. However, with the questions provided, did you want me to just go ahead and read out or provide responses? Okay. So the question is, are healthcare providers required to obtain medical malpractice insurance coverage? It is my understanding that it's not necessarily required. However, that's a good question that regulatory or health networks should be able to provide an answer for specifically. How many healthcare providers in Guam have medical malpractice insurance coverage? I can't speak on behalf of the entire insurance industry. We have an estimated 30 plus risks in which medical professional liability insurance are provided or issued on behalf of. So that doesn't necessarily give a number of the number of medical professionals that are covered under those coverages, as some policies may be issued for business entities that may be clinics or health networks that may have more than one provider. Sorry, excuse me. How many healthcare providers on Guam do not have medical malpractice insurance coverage? We're not aware of the number, as there's no data available that we're aware of. How many insurance companies on Guam offer medical malpractice insurance coverage? I am aware that there is one admitted insurance carrier, but they do not write all specific, or they don't cover all medical services. It's very restrictive. But generally, if brokered, medical professional liability may be available to most insurance providers on Guam, or insurance licensed producers or brokers. Do we have healthcare providers on Guam who are insured directly with off-island companies, not via a local insurance agent? Possibly so. If they're connected with an off-island affiliated health network system, I think Cedar Sinai and other outside medical professionals extend their, or provide visits and provide their services on Guam. So I would assume wherever they obtain their medical professional liability insurance would extend to Guam. How much can they expect to pay for medical malpractice insurance annually? Minimum premiums may range from as low as $3,500 a year to over $100,000 a year. It all depends on the risk exposure. What considerations are made relative to how costs for medical malpractice insurance are determined? Well, it'll be based on the risk exposure, the type of services they provide, the volume. Definitely their claims history would be a factor. Guam is a unique place to do business, to do insurance business, as volume, so location, Guam's locale can also play a factor. So they may have a higher minimum premiums for Guam as compared to that of the US mainland. Do insurance companies increase premiums if healthcare provider has multiple claims? Again, each individual risk are based on their experience. So obviously, a practitioner or medical professional with no claims may be extended certain credits or discounts because of their clean history as compared to one with a high frequency of claims. And also a practitioner who has, or a medical professional who has a high frequency of claims or claims existing in their history may not be able to obtain medical professional liability insurance. What is captive insurance? And our clinics on Guam have this kind of insurance. Not too familiar what captive insurance is, as we do not deal with captive insurance. There possibly might be, they definitely might be existing out here for medical professional liability insurance. Can doctors self-insure without going to any insurance company? I would assume they can, granted that nothing would preclude them from doing so. How many local medical malpractice complaints are settled during the arbitration process, and which party prevailed in each case? That information not available by us or to us, as medical claims, or I'm sorry, claims in itself are handled directly by the insurance carrier and their local legal representation. What is the difference in premiums when a doctor is first opening up his or her practice? It all depends on their type of services. So, if you're in general practice, internal medicine, or general practice, pediatrics, their premiums would definitely differ than that of obstetrics or OB-GYN or surgeons or anesthesiologists. So it would, again, vary, and it'll be predicated or dependent upon the risk exposure, the type of services, their volume, claims history, et cetera. That's pretty much all I have available, unless there are other questions you'd like to address or pose.
Thank you, Mr. Polino. Are you able to elaborate on what you described as, I forget the word, but like a proficiency of claims, or where does that line get drawn, whether you have a lot of claims that is going to affect whether you get insurance or not?
When you're applying for insurance in general, if you have any claims, you're definitely going to be of concern to the insurance carrier, whether and the probability of claims reoccurring can also be a factor. However, with regards to anyone with claims existing or high volume or high level of claims, they definitely would pay a higher premium or not be afforded to qualify for medical professional liability insurance.
Yeah, are you able to expand on what is a high volume of claims?
The underwriting process of these type of risks are not underwritten locally. They're underwritten by the insurance carriers, whom are primarily off island, so I'm not able to provide any estimated number.
Okay. All right, well, thank you very much, Mr. Polino.
Thank you.
We will accept questions from the panel after the testimony of Mr. Joe Takagi. If you could state your name for the record, please.
My name is Joe Takagi. Madam Speaker, committee members, good evening and half a day. Would you like me to also go through the actual questions again?
Yes, if you could. And if you could just move the mic close to your,
Okay.
or you can say whatever you like as well.
Okay. So the first question was asked was, are healthcare providers required to obtain medical malpractice insurance coverage? I am not aware of any federal legislation or local laws that require this for medical clinics. The second was, how many healthcare providers on Guam have medical malpractice insurance coverage? I would not be able to answer this as I don't have the data in regards to how many clinics have medical malpractice, so I wouldn't be able to answer this. Third question is, how many insurance companies on Guam offer medical malpractice coverage? Now, I can't speak on behalf of all insurance carriers, but I also believe that there's only one insurance carrier that does provide it as an admitted carrier, but I don't think they're actively writing it. Medical malpractice coverage is very difficult to get, and it's gonna go into one of the other questions, but most of the time, insurance carriers here, at least the admitted ones, because they cannot procure medical malpractice locally, they have to go through, they are what is called surplus lines brokers. And what that essentially means is that we have to go through a process where all insurance carriers are first asked whether or not coverage can be attained here locally for the admitted carriers. Once we cannot get that insurance coverage, we're then allowed to go off island once we get the approval of the insurance commissioner. And through that, we use what is called brokerage. And these brokers will then go around the world trying to search for coverages on behalf of our clients. But the problem is that in many cases, a lot of carriers are not familiar with Guam, or they don't want to write Guam because of the fact that the market is very small. And so there are different reasons for that as well. So we end up going to the same carrier, if any, and so that's kind of where the problem lies as well. So, but for locally here, again, it's very rare that we would be able to find any coverages here. Next question is, do we have healthcare providers who are insured directly with off-island companies? Most of the times, as I mentioned previously, we all go off-island through surplus lines brokers to try and look for medical malpractice coverage because we cannot get it here locally. How much can a healthcare provider, depending on your specialty areas, expect to pay for medical malpractice insurance annually? Again, we don't have data in regards to all clinics here, but medical malpractice can go anywhere from a couple of $1,000s to the millions. So it can reach that high. And it just depends on in regards to the size of the clinic, how many employees, what kind of doctors there are, and what they do as a service, right? So the premiums can go high as well. What considerations are made that your company is limited to share relative to how costs of medical malpractice insurance are determined? I cannot really mention in regards to the details because it's the carrier that makes those decisions. But the carriers usually look for loss history. And the loss history is in regards to what claims have already been paid out. They also look at the loss ratios. They compare the premiums to the actual losses. And so all that will come into place as well. They'll look at the risk, and that's what it comes down to, the risk in regards to what they're insuring. All businesses need to make money in order to continue. So again, if the losses are so high, insurance companies at the worst will no longer issue insurance policies here, or they may most likely increase the actual premiums as well. So it just depends. Do insurance premiums increase if a health provider has multiple claims? Probably. It depends on regards to the severity of the claim and how much they paid out. As I mentioned, the loss ratio is basically dependent on what the actual insurance company or carrier will do. If the actual payout is much higher than premiums, again, most likely there will be large increases in premiums, or again, they may decide not to write in Guam. What is captive insurance, and are there clinics on Guam that have this kind of insurance? I can't really speak too much about captive insurance as we don't provide that service anymore. But captive insurance is essentially an insurance company of your own. And what that means is that when a client can either not find any insurance, basically a carrier willing to provide the coverages, or it's too cost prohibitive to actually buy insurance, which basically is the formation of your own insurance company. And whether or not this is being done, I don't know. Can doctors self-insure without going to an insurance company? When you don't buy insurance, it's essentially self-insuring. So yes, you can. How many local medical malpractice complaints were settled during the arbitration process? And which party prevailed in each case? I don't know. I don't have data on this, so I cannot accurately give you any details on this. What is the difference in premiums when a doctor is first opening up his or her practice? Again, this would come down to the actual underwriting of the carrier. Again, they would have information in regards to the applicants, how many doctors are, what services are provided, the loss history of the actual company. And so there will be information that's needed, and to be able to answer this, we'd have to, again, refer back to the carriers. And that's basically all I have to say at this moment.
Thank you, Mr. Takagi. Can you, could either of you tell us, covering providers on Guam, how many?
I'm sorry, can you?
Are there of your companies covering medical providers on Guam, and how many providers? Or
Is our carrier providing insurance?
Yes.
No, our insurance carrier does not provide medical malpractice on Guam.
Mr.
Yes.
Mr. Polino?
My apologies. Can you repeat that?
Is your company, Cassidy's Insurance, providing medical malpractice coverage on Guam?
Cassidy's is general agent of the admitted insurance carrier currently writing medical professional liability on Guam.
I'm sorry, it's muffled. Can you just repeat that, please?
Cassidy's is the general agent Cassidy's is the general agent for the insurance carrier currently admitted and writing medical professional liability insurance on Guam.
Okay. So, all right. Thank you. So, okay. Thank you very much.
Thank you.
I want to note for the record that we also received testimony from David Silva. He says he is the general manager of AB Risk Solutions, a professional insurance broker formerly known as Aon Micronesia. I wasn't aware of his testimony prior to the hearing, so he's not here today, but we did receive his testimony, so that will also be provided on the website to all my colleagues and sent to all my colleagues. So, okay, if we're going to proceed now with questions, if that's okay with everyone, and sorry, just give me 1 second. I guess I'm going to begin with you, Mr. Thompson. I want to clarify, first of all, this the comment about the small claims. So that provision, of course, was included. So we exclude any claim under $10,000 in this bill from small claims. I mean, from arbitration, and we direct that towards small claims. Currently, the regular cap for small claims is $10,000. For other cases, any other kind of case, and that was actually a recommendation made at one of the hearings. So if we did not provide this exception for claims below $10,000, you're advocating that a $10,000 claim should require the filing fee at arbitration of $10,000 plus arbitrator's fees in order to resolve that $10,000?
Well, Madam Speaker, first off, the $10,000 arbitration filing fee that's been bandied about, that doesn't apply in every case with the AAA. The AAA has a sliding fee schedule so that if your claim is for X dollars, the fee is Y. And then if your claim is X plus, Y, then basically the larger the claim, the higher the fee. So the $10,000 fee is if you don't want to set the amount of the claim. That's the only reason that the fee in the case that Mr. Keogh referred to was $10,000, because his clients did not want to state the amount of the claim, and AAA said, well, in that case, the filing fee is $10,000. So I disagree that the filing fee is always $10,000. I don't think that's accurate. The other thing is there are other arbitration providers besides the AAA. There is a respected arbitration administrator in Honolulu, Dispute Prevention and Resolution. They don't charge a filing fee. Zero, no filing fee. And I'm aware that Dispute Prevention and Resolution, or DPR, is currently administrating an arbitration proceeding here on Guam. Mr. Keogh represents one of the parties. And my understanding is it's proceeding just fine, a zero filing fee. So I just wanted to clear that up because I think that's a misconception.
All right, isn't it true that the DBR company that you talk about is that claimants can go to that company only upon mutual consent? Otherwise, they're going to have to file their claims with the AAA company?
Well, I don't know that there's a requirement of mutual consent. I think a claimant can file their claim wherever they like. And there are other providers as well, but again, I think it's important to note that the AAA isn't the only game in town.
Right, but it is the one that if the claimants don't agree, that's the one that a claimant must go to.
Well,
Under the DBR, isn't it also, possible that under DBR, it's like our other arbitration, our Guam arbitration law, where the parties decide how many arbitrators they want, and it's not necessarily true that they always have doctors on their panel?
well, that's true, Madam Speaker, but again, I think the point, to answer your question, is I think that the claimant can submit their claim to any arbitration provider that they like. And then, of course, if the parties agree that, look, we want one arbitrator rather than three, if the parties agree to it, I don't see what the issue is.
All right, well, hopefully then the arbitration provision of this bill provides exactly that the parties are going to agree where they're going to bring their arbitration, and that is still absolutely available to doctors and claimants, and to decide whether their arbitration that they are going to pursue is going to be one panel, by one lawyer or one doctor, as some of the cases have been, and without necessarily, incorporating filing fees and the arbitrator's fees of that other company. When you talked about the jurisdictions that you looked at that had screening panels, I also found 23 jurisdictions without any screening panels and that allowed claimants to go straight to court, straight to trial. And so again, I just want to stress that this bill still provides screening. It still provides a different process for doctors that is not allowed to any other sector of our community and is not allowed in every other jurisdiction that this special protections are afforded. So, and in the jurisdictions that have screening panels, they're different, as you described. There's such a big variety of them, but I don't think there is none that has a mandatory arbitration, is there, except for Guam?
Yes, that's my understanding.
Okay. I'm sorry, I think I misspoke. I think my bill does, this bill allows small claims up to $20,000, which is twice the amount of the regular small claims. And I remember there was a person testifying who had, I think it was like Mr. Keogh explained, it was someone who had a claim against a veterinarian for a small amount, but in order to pursue that claim was going to have to go through arbitration. And so this is just a way for small claims below $20,000 to have a different process, just like we allow claims right now, and that is hopefully to just get quick settlement as to those without extreme costs for such a small amount. Mr. Keogh, you gave us a breakdown of the filing fees for arbitration. Do you agree that this is going to the one company is that a claimant can go to any company that they want for arbitration at this point?
Yes.
Under the current law, yes. Mr. Keogh?
I'm sorry.
Do you agree that that a claimant can go to any company that they want to file their mandatory arbitration claim currently, under the current law.
Under the current law, you could go to anyone who would be willing to take it, but DPR, for example, has no arbitrators on Guam. They have no doctors on their panel. And so to go to DPR, you'd have to agree to abrogate the statute. So you have to agree to it that you can only have, actually all of their arbitrators are retired judges or lawyers. They have no doctors and no non-lawyers on their panels. So you have to have an agreement to do that. And the one case that Mr. Thompson referred to, it was agreed to go to DPR with one arbitrator, and the defendants agreed to pay all the costs. And that's why it went to DPR, is that we agreed to do that, rather than go through 3 arbitrators through the American Arbitration Association. As far as others, I know of no others. And we've looked around to try and find other agencies that would arbitrate cases. There's one called JAMS, but they're more expensive than the AAA. So why go to them? And as far as the filing fee, yes, DPR does not have a filing fee, but they charge $450 an hour for each arbitrator. And as far as the AAA's filing fee, it's true it's on a sliding scale, but if you don't specify an amount, which you have to say, well, I'm only claiming $300,000. If you don't specify an amount, or if it's an amount $1 million or more, it's $10,000. So, sometimes people don't want to prejudge the dispute by saying to the arbitrators, I'm only asking for $300,000, when you might be able to be justified in asking for more. Most times in court, plaintiffs don't have to specify how much you're claiming for. It's up to the jury or the judge to decide. But with the AAA, you have to say the amount or pay $10,000. That's your only choice.
All right, but when you said abrogate, you have to abrogate the law in order to get to this other company that has no filing fee. What do you mean by abrogate the law? Are you talking about, my reading of the law says that it has to go to a 3-person panel, as described in this statute, that consists of 1 lawyer, 1 doctor, and 1 non-lawyer or non-doctor, or N.
Yeah, that's a problem, that if you do it without doing that, as we're doing in this one case, it happened to have been approved by the court in that one case, but if you just do it on your own, is that going to be upheld on an appeal at some point, that you didn't follow the statute? It's a problem.
Okay, yeah, well, that's what I guess the bill is trying to allow other types of arbitration that don't necessarily have to have the 3-person panel, the very costly panel, or go through that particular firm that has the costly filing fee, and that it allows Guam arbitration law to be used, and so that allows parties by mutual consent pretty much to agree to any type of panel and any, the location and the costs of the arbitration, so that is still possible to all the parties under this statute upon agreement, just as the Guam arbitration law applies to all other claims by mutual agreement. Okay. So Ms. Attorney Thompson, you also talked about, other suggestions that are actually not in this bill, including caps, and those are, like you said, they have those in other jurisdictions. That's not within the scope of this bill, but you also talked about another bill that was withdrawn last year by the sponsor. But that bill also acknowledged that the costs of screening of the current arbitration law were prohibitive. And it was very much directed, just as this bill is directed, to addressing the costs and allowing those people who cannot afford the current arbitration process to have alternatives. And that bill, however, required that the government was going to put in $100,000. It allowed for a lawyer, the Attorney General, to be the one to decide whether the claims had merit or not. And it allowed, and then it, required doctors to put in about $150, I think. And when we did the calculations on that, I think it looked very obvious to me that that was not going to cover the costs of, any more than 3 cases at the rates that had been put forth at the hearings as well. And that it looked like it was either going to require additional fees by the doctors or additional taxpayer money to be put in. And so that's one of the reasons why we looked for lowest cost to the taxpayer in this, magistrate that is actually already, under the tax roll or the taxpayer's claims. And I know that there's been a lot of talk about that, and you brought it up, and I just wanted to clarify that, we have considered many of these suggestions and tried to come up with something fair. Okay, so other questions I have? Would you have the same objection, I guess, to the magistrates? You're saying they're not as qualified as doctors in making these decisions, but if I had put judges in the bill instead of magistrates?
Well, Madam Speaker, again, my concern here is that to me, in my opinion, it makes sense to have healthcare providers be part of the screening process. Unfortunately, there are expert witnesses who are more interested in a paycheck than in necessarily providing independent and excellent advice. And so just because you have one side has an expert witness who says something, that doesn't necessarily mean that opinion is well taken. And I think if on the screening panel we have a healthcare provider, he or she is more likely to be able to determine that, well, that expert's opinion really isn't very accurate or persuasive. I'm not saying that a judge can't do that, but I think one of the reasons why many jurisdictions that have a screening panel system have healthcare providers as part of that system is to provide the expertise to evaluate the competing expert claims. Okay.
If the, again, so if the magistrate, if parties do not like to go to a magistrate, they can opt to go to arbitration. And I understand, they can agree to arbitration according to this bill. And magistrates are really for when they cannot agree. And that we're trying to find some person at low cost to objectively handle these cases. And I don't know if I said it earlier, but in my research, so the magistrates, they are appointed by the Supreme Court Chief Justice of the Supreme Court of Guam. They are vetted through a confirmation process here at the legislature and confirmed by the legislature. And they are sworn to the same code of ethics as the justices of the Supreme Court and all judges of the court as to conflicts of interest and things like that. And so in trying to find somebody who could serve in this capacity, outside of judges, that I thought that would be a very good fit because of the requirements that they already have to go through and because of the ability of the parties to present expert testimony on both sides to counteract each other, to counter each other's expert testimony. And again, because if they really want a doctor to be the arbitrator, then they can agree to that and go to arbitration as well. There was a recent malpractice case at the Federal District Court where Judge Magnolia questioned the constitutionality of the law. And this is in a newspaper article. I did not get the decision, but it says that she was quoted saying, quote, "It would be manifestly unfair to enforce a statutory requirement against a person financially incapable of arbitrating. Doing so would have the absurd result of prohibiting the poor from recovering on a claim they might be otherwise entitled to. It would likewise shield the healthcare industry from ever owing liability to the underprivileged." So again, we're just trying to find a middle ground here where we are not going to have this type of decisions coming out from the court regarding our statutes, there are laws that we have in place here in Guam. And again, we talked a little bit, both of you talked about incentives for settling within, either arbitration or settling under the magistrate, and that whether there were penalties for proceeding to court. And I guess that's my final question. So if you could just expand on that a little bit more. So you're saying there's no incentive for a person to settle with these confidential procedure, this confidentiality, this, by having their case screened with a magistrate and their expert witnesses, that would not entice them to settle prior to trial?
Well, Madam Speaker, as I mentioned earlier, under the current law, if the party that loses in front of the arbitrators wants to roll the dice with the jury trial, there's a risk. And so if they lose again, they have to pay the other side's attorney's fees and expert witness fees, which in a medical malpractice case often are quite high. It's true that under the proposed bill, the magistrate judge's decision will go in front of the jury, but and I don't usually represent plaintiffs in these type of cases, but if I was representing a plaintiff that lost in front of the magistrate, I would say in my argument to the jury, look, the magistrate judge who issued this opinion, he's not a doctor. She's not a doctor. There wasn't a doctor on this panel. And you've heard from our expert, Dr. X, who explained why the magistrate judge was wrong. And so I don't think that that's a real disincentive for a party that loses in front of the magistrate judge to go forward. And I think that if one or more healthcare providers were on the panel, it would be much harder to make the argument that I just outlined.
But when the case goes to trial, it's in the 23 states, it's being heard by a judge without any who are not also doctors. And there are arbitrations that are proceeding, as you said, where the arbitrators themselves are not at all doctors, and there's an entire company, I guess, Mr. Keogh, you're saying, that does not have any doctors on their arbitration panels, and those are also being used?
Well, Madam Speaker, what I was trying to suggest that there's not a real disincentive in the bill as written, because there's no financial disincentive. In other words, unlike the current law, if you lose in front of the jury, you don't have to pay the other side's attorney's fees or legal fees. The only consequence is that the jury is told about the magistrate judge's decision. But what I meant to suggest a few moments ago is that I think a magistrate judge's determination, in particular when there's no healthcare professional as part of the screening panel, would be easy to attack. And so I don't think it's a real disincentive to stop somebody from pursuing a claim. I think it's interesting to note that under the current law, the arbitration award is expressly prohibited from being presented to the jury. In other words, the jury doesn't know how the arbitrators ruled. And I think that the intent behind that is so that the jurors are not swayed one way or the other, but that they determine this on their own. Again, I think the deterrence under the current law is the financial penalty if you lose in front of the arbitrators and then you lose again in front of a jury.
All right, Mr. Keo, if you could expand on that question, please.
Yes, thank you. Actually, I think Mr. Thompson just gave the best argument in favor of the current law, is that when he says that there is no financial disincentive, of course there's a financial disincentive. You have to go through a trial all over again. You have to pay your expert witness fees. You have to pay your other litigation costs. But the disincentive is any defense lawyer is going to argue to a jury, if you're on a retrial, that this case was already heard by a magistrate judge, and the magistrate judge decided it this way. And now they're taking a second shot at it and trying to get you to overturn it. That's the disincentive. The penalty under the current arbitration law is so draconian, and actually it doesn't make any sense, because it says if you don't improve your position, the appealing party doesn't improve their position by 40%, then you have to pay the other side's attorney's fees, not expert witness fees. There's nothing in the statute that says you pay expert witness fees. You pay the other side's attorney's fees. But how do you, let's say you got nothing from arbitration. How do you improve nothing by 40%? It makes no sense. So this, the Bill 112, provides a very cogent mechanism for appeals and a disincentive. You have that magistrate's decision that's hanging over your head. That's the sword over your head when you go to a retrial if you declare one. And for the most part, if you had a judge, like a magistrate judge, already listen to all of your testimony, listen to your experts, and give you a decision, you're going to be seriously guided by that decision rather than to seek and go on for a new trial.
Thank you very much. I'd like now to open it up to the co-sponsor, Senator Terlaje, and the other co-sponsors to ask questions.
Situs Masi, Madam Speaker, for the opportunity, and I'd like to thank everyone who's here today. I hope you brought a banana or a granola bar to help you through this, but I greatly appreciate you being here today. I think I'm going to start with the insurance companies. I had the opportunity to speak with Cassidy's and Takagi's Insurance, trying to get some information. And I think, Victor, I received from Cassidy's Insurance a description of medical specialists or doctors, pharmacies. And I have a dental clinic, I have a surgery surgeon, and I have premium amounts that were also given to me. In here it says an individual general practitioner. This is like 1, 2, 3, 4, 5, 6, 7, 8, 9. This is 9th from the bottom. An individual general practitioner. How much premium a year is that for that doctor, a general practitioner?
That reflects $3,500.
For a general practitioner. There's one here that says 5,666. I think that's the one I'm looking at. That's insurance premiums a year.
That is correct.
Okay. Let's go up to a surgery, where it says surgery. What is the amount for a surgeon there for premiums a year?
That is a general classification, surgery, not necessarily the surgeon.
Yeah.
That premium is $31,145.
You mentioned in your testimony, premiums can go anywhere from $3,000 to, I think you mentioned $3,000 to
Over 100,000.
100,000, and then of course, Joe from Takagi Associates went to 1 million. The reason why I'm bringing this up is I was really shocked to see the premium amounts for doctors in here. I have another one here, a dental clinic at $15,900 for yearly premiums. And then I asked the question, how are premiums determined? Basically through, you mentioned through demographics, the area. In other words, a doctor who's practicing, just a general practitioner who's practicing in Beverly Hills, his premium amount versus the same doctor, moving to North Carolina, like Fayetteville, North Carolina. What would be his premium amounts in that area? So it was explained to me that a doctor in an area where those who are seeing those doctors are basically who can afford to sue a doctor in Beverly Hills, their premiums for a doctor would be much higher than the doctor in Fayetteville, North Carolina, where the community there doesn't have that much money, or they're average people, farmers in that area that don't have that much cash. Would that be true to form if one doctor versus another doctor in two different locations on demographics, would that determine the rate of premium?
I can't comment for those other locations as I'm not a licensed insurance professional there. However, with regards to Guam and its uniqueness, the factors vary. Guam in itself has already, by locale, has already a unique starting premiums. And I want to clarify, the premium amounts I mentioned earlier are starting minimum annual premiums. That's just the insurance carrier saying, this is the minimum I'm going to charge if we decide to write this risk. And then again, other factors would be the volume, types of services, medical professional services, and how many practitioners within their policy, and claims history. So Guam is unique. The good thing is medical professional liability insurance is available. However, there was at one point in which it was very, very difficult to even try to place one single risk. I would estimate about 10 to 15 years ago.
Okay. Mr. Takagi, you mentioned that you don't carry any medical malpractice right now. Is that true?
Yes, excuse me. We are general agents for Iowa Nisei Doa, who is our main carrier, who we write for. So
Okay.
they don't provide any medical malpractice.
Did you at one time provide that medical malpractice?
No.
Okay. Do you have the opportunity as an insurance company on Guam to seek that type of coverage to a carrier off island? Like you mentioned earlier.
Yes.
Yes. So you, that ability
yes.
to do
So
so.
in most of the cases, we all have to go off island through a surplus lines broker to try and search for medical malpractice because it's not readily available here.
Okay. And right now, I was counting, actually, there's Takagi, well, you have the ability to do so, as well as Cassidy's, as well as Moylan's, and I believe a couple other insurance brokers, not brokers, but agents on island that also have that ability to cover medical. So yes, we've come a long way to be able to provide the medical malpractice insurance. Mr. Keo, so thank you so much, gentlemen, for that, for the information. And again, the demographics is so important. Guam is considered to be, our island, 80% of our people live in poverty. And a lot of times I was an insurance agent, certified insurance agent for 3 years. And one of the determinations of premiums is based on the ability for individuals to sue. And when you have an island that is 80% living in poverty, it makes it very difficult for anyone to sue for it. So I'd appreciate later on if you can provide some data and information regarding the determination of the premium amounts, based on area and location. If you can, I'll get with you on that earlier. This legislation, I think we all want that balance. We're working very diligently. In fact, we've been working on this for almost 2 years to find that balance. And most especially those victims or patients who feel that they were wronged or lost a loved one. Sometimes it only takes someone from the outside, someone who's not the doctor, to tell them that their loved one had passed away based on complications, not on medical malpractice, but just on complications. And sometimes that party from the outside can resolve that, hurt and sorrow that's happening from these individuals. They're angry, they're upset, they're sad, and they just want an answer. And I think this opportunity gives them that through the magistrate, to provide that information. I'm not going to go further on to the magistrate judge, but Attorney Keogh, if you could please, on your testimony that you submitted, can you please read the section on page 4 of your testimony where it starts at the bottom, standard of care. And could you please read just that section 4 where it says standard of care into the record?
The comment about many doctors have commented that due to Guam's remoteness and lack of doctors in certain specialist fields or absence of specialized equipment, they will be more subject to suit because they are forced to perform services for which they are not trained or for which they lack the necessary equipment. The solution to this fear is the provision in the bill containing the community standard of care. A doctor can only be held liable for treatment that was below the standard expected of a physician in his or her field within the same community. For example, a Guam family practitioner cannot be held liable for failure to perform treatment to the level of a specialized physician or for failure to refer a patient to such specialized physician when there is no such specialized physician available. Similarly, a doctor cannot be held liable for failure to utilize specialized diagnostic equipment when treating a patient if no such equipment is available on Guam. This is what the community standard of care means.
And this is part of Bill 112, is that right? This section here is part of Bill 112.
Correct.
Okay. I was talking to the director of Guam Memorial Hospital, Lillian Posadas, and I asked her the question, if a child with diabetes who comes in with a diabetic seizure comes into emergency, and there is no pediatrics diabetes specialist there at the hospital, what do they do? And we were talking, and she mentioned that, well, we stabilize the child, the individual, and through telemedicine, they usually at a call, making a phone call to someone that specializes in that area off island, and they make these phone calls. So they're an opportunity for them to at least stabilize the child, keep the child, safe as much as possible, and they have the assistance of that individual to assist them. If that same situation comes up and anything happens to the child, did the hospital, and I know the hospital is not part of the medical malpractice, but it could be to any situation, any doctor. If that same scenario happened and something happened to the child, would that doctor be considered, would he be said to have created medical malpractice in the event that the patient should die, but they've done everything they can to stabilize and make the phone call to someone in that specialized area?
It's difficult to say, but it would seem to me, in order to establish that that was malpractice, you'd have to have some qualified expert say that the treatment was below the standard of care in the community of Guam. And frankly, I can't conceive of that happening if they've done everything they can within their capabilities and their available equipment here on Guam. then that's what the community standard is.
Okay. Mr. Thompson, the same question to you, please.
Well, Senator, I'm not really prepared to kind of respond to kind of a hypothetical like that as far as what could or could not happen. I am able, however, to discuss this comment by Mr. Keogh about standard of care. I have defended cases in which the plaintiff's counsel have argued just the opposite, that if a general practitioner takes on services which normally should be provided by a specialist, that the general practitioner should be held to the standard of the specialist. And I've also had cases where the plaintiff's counsel has argued that the standard of care in Guam should be the national standard. So I find it interesting that these comments here are from the same lawyer who argued differently in cases in court. So I think it's hard to answer your hypothetical question. I'll just leave it at that.
Okay, thank you, Mr. Thompson. But, we got a lot of, people, a lot of comments that are being floating around there with hypothetical questions, and actually doctors deciding not to, or, threatening they're going to not treat patients anymore because of, it's not in their field or specialized. I think it's important that it's brought out in the open about the standard of care and the obligation, the ethical and oath they take to protecting and doing their part as a physician. The oath they take, the ethical, moral part that makes them who they are today, and that is to help those who are sick. And if a standard of care is in this legislation, Bill 112, that the doctor's doing everything they can possible to assist and help this individual would not render a suit automatically just because they're not in that specialized field.
Well, Senator, maybe this will help. And the providers, I think, can answer this question better than I can. But I think the concern is this, is that you're absolutely right. The providers want to help their patients. They really do. But the concern is, let's say the patient, if we were in Beverly Hills, there'd be not just a specialist, but a subspecialist that would be expressly trained and experienced to handle that patient's illness. But here on Guam, we don't have that luxury. And so the option is for the provider is, well, he or she knows that this patient really should be seen by a specialist or a subspecialist. But there's no such person here on Guam. So what does the provider do? If he or she elects to treat the patient, the concern is that if there's a problem later on, the claim is going to be, well, you weren't a specialist, you shouldn't have treated this person. Now again, what the outcome of that case is, we don't know. But the concern of the providers, I think, is that if it's just the fact that the claim is made and now they've got to defend a claim, and if they don't have insurance, it's really a concern because they have to pay for the defense on their own. And so it's not even necessarily the ultimate outcome of the case. The concern is if we provide treatment, which arguably should have been provided by a specialist, then are we opening ourselves up for a claim along those lines?
Thank you. Mr. Thompson, since you brought this up about the PDN opinion this afternoon, I kind of read this. It was ironic that you brought it up because I wrote it down earlier today when it said people have complained that medical arbitration is costly as a first step prior to litigation. If that's the issue, then fix it. Okay, so Bill 112, basically, don't you think it fixes that? Because it talks about the costly litigation with regards to this. I mean, it's even more difficult, not just on the cost Mr. Thompson, but to find attorneys to actually take these cases, it's been very difficult because they know that the process is not in the favor of the patient at all, or those who want to seek justice. And the ability for an individual to seek justice in the justice system be held back from going forward. But when it says, then fix it, tear down the entire medical infrastructure when the problem is so straightforward. So you mentioned that earlier, and I was just surprised because I interpret this as, then fix it, take the cost away, and I think what Bill 112 is going to do is do just that, to provide that screening process first for frivolous lawsuits, and provide that also ability for things to be confidential, which is not given in the current legislation. So the last question, and you know, I actually reserve for later on, Madam Speaker, and allow my other colleagues, but Attorney Keogh, can you please explain of the bill, in the bill, on page 7 of Bill 112, on page 7, section 10110, can you explain the definition of curse? Because this, to some people, and I've had a constituent call me and ask me that, does this mean that you can actually go back to certain issues or make claims from in the past? So can you explain what that section is on 10110, page 7, occurs, mean?
Yeah, I don't have the bill in front of me right now, but I think what you're talking about is whether the bill applies to claims that have accrued. And for a claim to have accrued, there is a 1-year statute of limitations on Guam. So it can't go back and look at cases that are more than a year old, 2 years old, 3 years old. If the case has accrued and it is within the statute of limitations, it can be applied in this process that's set by the Bill 112.
So basically, if this bill were to pass, it can only go back 1 year then, is what you're saying? In other words,
yes.
Yeah, if the incident happened, you know, within the current law, allows an individual to seek a claim after discovering it within 1 year.
Thanks.
So if the incident happened 3 months later, the individual realized that there was an issue, or discovered an object that was, you know, accidentally left in the body like 3 months later, they still have that opportunity to, within 1 year, file a claim. Is that as simple as putting it? So
Yes.
this section of the law on page 7, accrues, it means just that. It allows that 1 year statute of limitations, but doesn't go further back than that, correct?
That's right. It does not.
That's right?
Correct.
Okay. So I just wanted to make that clear, Madam Speaker, because I've had a couple people ask that this statute of limitations they're concerned about that section, but it is only within the 1 year time that's already current in law that allows that. So, Madam Speaker, I'll just yield to my other colleagues at this point.
All right, thank you. Senator Snogsty?
Thank you, Madam Speaker. Madam Chair. You know, Mr. Cute, I don't know if I want to murder your name or not. Cute?
Yes.
Okay, I guess I'm within range. I was just questioning how my previous colleague mentioned you gave the definition of what's on the bill on the standard of care. You gave the definition of standard of care, and I'm trying to find in the bill how you explain it on your testimony that it's the community standard of care. In the bill it says the prevailing standard of duty, practice, or care by a reasonable physician in the same field practicing medicine in the community at the time of the alleged malpractice shall be the standard applied in pre-trial screening. I was trying to follow along how your testimony defines something that's not defined in the bill at all. And I would ask the author of the bill that maybe if the intent was to define it, then we put in the definition section exactly what standard of care is defined as, not, just you saying it, because I can define standard of care as different from what you're saying, and I just want to make sure that there's a balance here. But I have no problem with the way you defined it, but I just want to be able to see it. Because when the bill goes through the motion and it gets passed, your testimony will not ever show. It will never exist. So that's one strike, which I like your definition, okay? If that's the community standard, I just wanted to make sure that we're consistent and everybody understands that. Other than that, Madam Speaker, I really don't. I'd like to thank all of you gentlemen for being here tonight. I look forward to the public hearing on the bill so that others will come in and start testifying and start expressing their feeling. I'm one of the co-sponsors of the bill, and yes, Sir.
May I comment to the standard of care question?
Okay.
I mean,
all right.
Mr. Thompson made a pretty serious accusation against me, as he often does. The standard of care in this bill is the exact same language of the standard of care as stated in the current law. And standard of care is defined by judges and doctors who are giving opinions as to what the standard of care is. As far as a national standard of care, I've never argued there's a national standard of care, as Mr. Thompson said. The statute says specifically it's a community standard of care. However, every doctor who's licensed to practice on Guam has had to be educated in a U.S. medical school or have gone through a U.S. Residency or specialty training. So the doctors practicing here are U.S. trained doctors. And so they are trained under U.S. standards and apply those standards when they're practicing here. But the community standard of care is, as I've discussed it in my testimony, depends on the circumstances that are presented to you in the community. And that's to be decided on a case-by-case basis. There is no specific definition for it. And
I understand. I just wanted to be able to see it in the bill so that everybody understands because of what we're in. OOG only on Guam. This is how it's defined. It could be a national standard, could be whatever. And I agree with you. I am not debating with you. You hit on the dot, so did Mr. Thompson. Great deal, because they're both lawyers. Thank you, Madam Speaker.
Thank you very much, Senator San Agustin. Vice Speaker Munir Barnes.
Thank you, Madam Chair, Madam Speaker. A couple of questions. If I may, Madam Speaker, so it's all right. I understand on the insurance component side there were some questions that were submitted, and I know, Mr. Takagi, you were reading, and I was hoping that if the questions were submitted to you, if you have written your answers down, if you can submit it to us so that we have knowledge of all the questions that were submitted to you, and then we have a recording or, hard copy of what was sent to you and what you've answered. If that's okay, Madam Chair, on that?
Okay, that's fine.
Because I know that it was given to you. And then I'll ask this to the insurance companies, or anyone on the panel, based on the passage of this bill, or if this bill 1112 were to pass, will it increase the cost of insurance, which has with any industry, if it's always passed on to the consumer or to the common man when changes are made. So I'm going to ask you guys first and then ask the attorneys to respond. So if this, with the passage of this bill, will it increase the policy? And I know that Takagi said you don't insure, but will that be the case?
Well, in my opinion, one of the things, again, is that all comes down to the insurance carrier that's writing the actual policy. And of course, they look at the actual claims history. So if they're not collecting in terms of premium-wise, and they're paying out more in losses than they are collecting in premium, of course it's going to go up. But the other thing you have to understand also is that because medical malpractice is not readily available on Guam, at least for admitted carriers, a lot of them have to go off island. And when we go off island, again, there are other factors involved as well. So, for example, these insurance carriers also have what is called reinsurance carriers, which are basically insurance for insurance carriers. And when the market changes, whether from a soft market to a hard market, it becomes more stricter in terms of new insurance rates going up for the reinsurance markets, and also in regards to whether or not those insurance carriers want to write for new policyholders. So it's not something where everything is calculated just based on loss. It also depends on the actual circumstances that they're going through as well in the insurance markets.
Mr. Polino?
Your question is, would it increase the insurance premiums? Insurance carriers, it will most likely be a reaction, and they're reactive. Can we tell if their insurance premiums will go up? Unless the frequency or actual claims will go up, the market will react. However, I would assume that and this is just my opinion, that the medical professionals would not necessarily change the standard patient care differently than what they're already providing. So if that remains as is and the frequency of claims does not arise, the premium should not be affected.
Thank you. Attorney Keough?
I'm sorry, could you repeat the question for me?
With the passage of this bill, will it increase the cost of insurance policy?
I really don't know. I mean, my understanding is that most doctors on Guam don't even have medical malpractice insurance. So I guess it would increase from 0 to something if they decide to get malpractice insurance. But I don't know whether or not the bill will increase premiums for those clinics and hospitals, for example, that do have malpractice insurance. I'm sorry, I just don't know the answer.
Attorney Thompson?
Madam Vice Speaker, I can't speak on behalf of the insurance carriers. I don't know exactly what they would do. It is my understanding, though, that some providers have been told by their carriers that if this bill passes, they're going to stop covering them. But I think that question might be better directed to the providers at the next hearing.
Thank you. And then just one more question, Madam Chair, if I may. Earlier you cited the section on lobbying, and so maybe just so that the record is accurate, did any of the parties testifying here tonight help in participating in drafting this legislation 112? Just to be, so the record is accurate. You said no, Attorney Thompson?
I can answer that. I've drafted this based on all of the testimony that I received at the last hearings, and in conjunction with Senator Taitakui, in fact, and my staff and many people.
No, I just wanted for the record, because it was brought up, and I do know that I received a call earlier from one of the attorneys at the suggestion of the author, so I just want to get it for the record. So if you say no, Attorney Keough?
I'm sorry.
Doesn't hurt to know.
I'm having a hard time hearing. What is the question? You're asking whether I'm being paid for testifying?
So on the panel, anyone testifying here, did anyone help in the drafting or participation in recommendations for this Bill 112?
I have not been paid by anybody to provide any
No,
testimony.
I didn't say paid.
I can't.
I didn't say paid. Did any one of you help in drafting or giving recommendations for this Bill 112?
I may have given some recommendations, yes. If asked, I would give a recommendation, yes.
Okay.
I didn't draft any of it, but I've certainly talked about it in meetings with various senators.
Thank you. Thank you, Madam Speaker.
Thank you, Vice Speaker. As I said earlier, it's very clear for me that, yeah, I have solicited a lot of help in drafting this bill and a lot of testimony, and we have received, in fact, a lot of testimony since last year when we introduced this very similar measure in the last term of the last legislature. Senator Ada?
Thank you, Madam Speaker, Madam Chair. I'd just like to thank the panel for being here tonight and giving of your time to give us the different views in this informational brief. It gives us a little bit more information as we move along towards the public hearing. And we're looking forward to the public hearing as to see where we go from there. But thank you, gentlemen, all of you, for your time tonight. Thank you for, especially, this is your personal time, so I appreciate all of you for being here. Thank you.
I'm sorry, Senator Ada?
That's it, Madam Speaker. Thank you.
Oh, thank you.
Yes.
Senator Brown?
Thank you very much, Madam Speaker. Certainly thank you also to all the panel members that have provided their input this evening at this informational hearing. I certainly think it's important to take in all the different perspectives regarding these concerns. But certainly from my view, and I'm not a doctor and I'm not an attorney and I am simply a legislator, voted as we are here by the people of Guam to hopefully address legislation that is in their interest. And it's trying to find the balance. I know Senator Tello had mentioned that earlier, and I also look at it from that perspective, is how do we find a balance in this process of wanting to ensure that our people do get, and we look at the basis of standard of care. I think that's what we're looking at, is how do we ensure that they do get that standard of care. And in the event, and we've seen circumstances where it has happened, where a medical physician may, through their care of an individual patient perhaps, not execute their duties and responsibilities, and something negative or bad happens to that patient that may affect their health and well-being, or maybe affects their life. Maybe they don't survive it. What recourse? What recourse does a resident and citizen of Guam have? Or if it's a family member, I think sometimes if you look at it from that perspective, if it's your family member, you probably fight even more than if it's for yourself. What do you do in that case? The whole judicial process is a very expensive process for anyone. This view that this is only something that, a certain percentage, yes, only a certain percentage of our community perhaps could afford to challenge these cases, even if they went directly to court, even if the arbitration panels didn't exist, it would be an expensive process. Even the, people that may think they're upper middle class, $40,000, $50,000, $60,000, $70,000 is a lot of money. It's a lot of money, and most people do not have the ability to have that available in their bank account, or even if they were to go to a bank and borrow it. One of the questions they ask you when you borrow money, are you in litigation? I've seen that on a loan. I thought, wow, that's an interesting question. Am I in litigation? Are they assuming I'm borrowing this money because I have to go fight a case? That's certainly took note of that, because that wasn't anything I was expecting. But I think that's what we're looking for, is how do we address that if there is a need for that? And right now, the way the system is set up, it almost makes it impossible for anybody, unless you're exceptionally wealthy, to have some recourse of justice in this process. And I think that's what we're trying to figure in looking at this in this proposal. And then yet, you know, I'm surprised, and I am, and I hope, hopefully, Madam Speaker, as we move forward in this and have a public hearing and have more of our members of our medical community come out and express their concerns. I've certainly seen the written letters and positions publicly in the paper and direct contact and calls to us and requests for meetings to further discuss this issue. The reaction is so immense and immediate that I certainly do want to get that perspective, because I'm a little concerned. Why are our physicians as concerned? Do they believe that this legislation is going to open up, that they're going to get sued left and right just because they take care of patients, which I know, I don't think there's anyone who would go through all the effort of going to medical school and pursuing this as a profession if they didn't have you know, passion for the work that they do, because there's so much involved in getting to that level to be credentialed to be a physician. So I'm sure it's not anything they take lightly. But how do we address that balance? And right now, it's difficult to see that under the current system as it exists. So while we are all going to have different perspectives on how we believe we can accomplish that, I think one thing is clear, is that we need to come up with something better than what exists now, because I don't see the recourse for most people. And I hope it's not a view that anyone is giving care that they don't have a specialty in because they don't fear being sued. That's the way I'm kind of interpreting the English language at the moment and what I'm hearing, because I'm seeing statements being made that we're not going to provide these services. I didn't know they were providing them to begin with if they were not specialized in those fields. So you got to wonder, are we getting that care? That's something I think we need to be concerned about, because if we're going to provide it, but if we're going to be threatened to be sued, we're not going to do it. That doesn't give me comfort. I mean, I've personally been fortunate enough to have some very good doctors over the years. I've never been in this position of having to worry about I'm going to sue a physician because they didn't give me proper care. I believe there's malpractice involved in the care that's been provided to me or any member of my family. But if it happened, what would I do? And could I even could I afford it? What do I do? Put up the house, the family land? What do I do so I can afford that? Arbitration, my only dealings in arbitration, I'm just going to discuss this because that's been my experience, had to deal with the Port Authority of Guam in a very expensive case to the ratepayers that involved an issue with regards to the lease that was granted to H. Wharf and a company that assumed that particular lease with the belief that they could challenge the port, that they were owed a significant amount of money. They believed they were owed, and that the port did not fulfill obligations with regards to an agreement on the lease, a long-term lease of this property. And that issue went on for many, 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 many years. But during my tenure as Port Authority, we had to go through the arbitration because that was what was included in the contract. It was a very expensive process. The decisions that were made by the three arbitrators, I mean, when I first heard it, I was almost like, get out of town, really? We owe $14 million on a lease that we don't believe is legal, because the law required it. I was in the legislature at the time the bill was introduced. I was the only member of the legislature who didn't vote for that bill. Not knowing 15 years later, I'm going to end up being at the Port Authority of Guam dealing with a lease agreement that was executed within months of that legislation being passed and signed into law. Legislation that always made me wonder, who is this being done for? I had that question. Ultimately, I'm the only member that didn't vote for it, and I ended up having to deal with it. That's the irony of this whole process. And we challenged that decision to the Supreme Court of Guam, because we didn't feel the ratepayers of Guam owed $14 million. And on top of that, the company wanted to charge us interest, so they believed we owed 17. And I'm sure as the months and years would have gone on, 18, 19, 20 maybe. In challenging that decision to the Supreme Court, ultimately, Supreme Court of Guam determined that the contract was not legal, and therefore the Port of Guam, the people of Guam, owed nothing. But it was a very expensive process to get to that decision. And that's dealing with an entity in our government that has far more resources than the average person on Guam. Did I, going through that process as a general manager, thought arbitration was the best thing? Probably not. I sat in those cases, and I'm not someone who goes to court frequently, but the view almost of arbitration on Guam, it was viewed that, even when it was being argued before the judge, after the decision was made by the arbitration panel, almost to the point asking why the judge was in the room, because they didn't believe the judge had any say. Because this is what the arbitration panel decided, and under law, that was going to be the decision. As if an arbitration panel could make decisions contrary to law. So even then, I had to sit there and go, I don't know about this whole arbitration process. There's parts of it I don't particularly care for. Just that view. I don't think arbitration panels should be making any decisions contrary to Guam law. That's why we have this process in our democracy. So personally, I have bias concerns as a result of going through that case to the degree or the view that arbitration is, most people would think this is something that should make it easier to go through it so that hopefully if we disagree, we can come to some sort of consensus and we can walk away intact, hopefully mutually intact. That's what it sounds like. Process is a little different, at least what I had the opportunity to observe, and certainly there's a bigger case than what we're discussing this evening with regards to medical issues in this community. But it does raise a lot of questions for me, and unfortunately, to much surprise, I'm in a position now, back being a legislator, that maybe that's something that I can look at. I just think we have to have fairness in the process. I don't want to put doctors up where they feel they're out there for target practice, because they definitely, most definitely, have a very, very important role of what they contribute to the health and well-being of our community. But we don't want to have anyone who's not a good doctor, not a good physician practicing out there that is harming our people and getting away with it. And I think that's a concern, certainly from my perspective as a legislator, that I have representing my constituents. That's what concerns me. Everyone can have their positions, attorneys can argue different points of an issue. But for me, the bottom line, and at the end of the day, that's what my priority is. That's what I'm concerned with in looking at making a decision with regards to this issue, as I'm sure many of my colleagues are. And I hope, Madam Speaker, that as we move forward in the hearings on this issue, and we get more input from the community, and more importantly, certainly the medical community, and also those in our community that feel that they have been wronged by this system. Because, for people, at the end of the day, it's what's here. It's what they feel in here if they feel that a member of their family, if not themselves, have been harmed. Money can never replace if some serious harm was brought to an individual physically because a doctor did not properly execute his or her responsibilities in the care of that person or that patient. No matter what the amount, will never repair that, especially physical harm, or let's say ultimately leads to the death of an individual. No money in the world could possibly replace that for someone, if not yourself, someone that you love and care about. No amount. But our people in our system have to feel some sense of justice, that they are receiving some sense of justice, because they have nothing else if they've lost someone they've loved and cared about because a physician did not properly execute his or her responsibility in the care of that person. And we're talking about standard of care. I'm glad that we elaborated further this evening on that, and I'm sure we'll have more discussions with regards to it. But Madam Speaker, I think that ultimately is certainly from my perspective what I'm looking at and what I'm concerned about. If there's an even better way beyond even what was proposed in this legislation that we can do to bridge these concerns so that we can collectively walk away from the table and feel that we've at least have some sense of satisfaction and comfort in this process moving forward, then that's ultimately what we would like to do. But I have to say the current system, for me, looking at this picture, I am not satisfied with it. I don't think you need to have all this money to find justice in this community. I'm bothered if that's the obstacle, if that's the hurdle we have to jump in order to get justice in this community. And it's not intending to target doctors. I don't have any desire to target any doctor. But I certainly want to make sure that a doctor that again, does not execute their duties and responsibilities as they should, and they bring harm to a patient, I don't think that's something we should allow to slide. And I am concerned that this bill has been put up in a way that projects that if this bill passes, we have doctors claiming they're going to leave Guam, they're not going to provide services, the sky is falling, and maybe it is. I don't see it, but I certainly look forward to the input of more of our physicians in the medical community to elaborate on that, explain that, not just to us as legislators, but to the people out of Guam out there as to why they are as concerned about this. We want to make sure they're protected as well. I mean, we also live in a very, gosh, you're attorneys. I mean, you make your living representing these type of issues, this and many other issues that come forth to be litigated. But we don't want to open it up either, that's just the focus of this whole issue, that the intent is to open this up just so we can make lives uncomfortable and difficult, and every physician's worried to death that, they're going to get sued. They turn left, they turn right, they go up or down, they're going to get sued. That's not what we want to open this up either, because there's nothing productive at the end of the day in having that view of this or any other piece of legislation. So I look forward, Madam Speaker. I appreciate the fact that we're starting this discussion openly and publicly, getting the input. I appreciate those experts that are here from the insurance community to give us some insight, and both of you as attorneys even having differing positions on this. I appreciate your input as well, because that adds to the discussion. And hopefully, like I said, hopefully as a result of this, collectively we can come to something or some middle ground that can address and allay some of those fears, but yet at the end of the day, not put the person at the table that is not standing here that I think has the most important interest that we need to protect are the people of Guam, to make sure that they are not being harmed, and if they are, that there is recourse. Because I certainly, if I was the parent, if that was my child, if that was my mother, my father, someone that I loved and cared about, I'd use anything and everything I had to go against somebody. I would use anything and everything that I have, as most people would, because it's here. And I think we need to remember that. Thank you very much, Madam Speaker, for the opportunity to comment on this bill.
Thank you very much, Senator Brown. Senator Taitago, you have another question?
Thank you, Madam Chair, for the Madam Speaker, for the opportunity. And again, I thank you. I'll try and make this as quick as possible. Question I have, I guess it's Mr. Thompson. Do most doctors in the U.S. carry medical malpractice insurance? Are you aware of that?
Senator, unfortunately, I really can't answer that question. I've lived on Guam for 35 years, and I just don't know the answer to your question.
Okay, Attorney Keogh, can you answer that question?
No, I don't think I could either. I suspect, though, that most doctors in the U.S. do have malpractice insurance. I can't say that authoritatively, though, but that would be my suspicion, my belief.
I too think that same too, that there should be at least 90% of those in the U.S. I know that Florida, actually the state of Florida, requires that every doctor in Florida carry medical malpractice insurance unless they can prove to the insurance companies that they can self-insure and have a bank account, like a bonding on the side to do that. So some states actually require that they carry that insurance. I read a couple articles actually recently, one from U.S. News that medical malpractice is the third leading cause of death in the U.S. Cancer is number 1, heart attack number 2, and 3 is medical malpractice. That was very shocking to hear. From both, even in the Attorney Law magazine, they even brought that in there if you want to look that up, that it's the third leading cause of death in the U.S. And Guam basically mirrors a lot of the U.S. And we're trying to get numbers and figures and data to determine how many have been claims, how many claims there were, claims that never got to court. And one of the questions I had to Attorney Keogh is the time frame to litigate through the current law. The process and how long it takes. I know through litigation, time is of the essence. And sometimes these cases can go up to like 2 years, even through the arbitration, take up to 2 years' time. And then at the end, if there's a trial de novo, if one of them don't agree with the decisions, you're already in the 3rd year or the 4th year. And a lot of information and data is gone by then. I know that when you're suing anybody, that time is of the essence. Information is very important right then and there. So in the time frame in the current law and the time frame that's in Bill 112, Attorney Keogh, what is that time frame differential between the two?
Yeah, it depends on the case, but I would say it is not unreasonable to say that 2 years to do an arbitration is probably an average, and another 2 years, if you're going to do a trial de novo, would not be unexpected to get a case through court. How the magistrate process is going to be accomplished is yet to be seen, but I would expect it would be a whole lot faster. You don't have to spend months back and forth selecting arbitrators and objecting to arbitrators and then paying for the arbitrators. You get immediately assigned to a magistrate judge and you get a hearing. You'll get a, I would think that could be done in 6 months.
Or less in some cases, because according to the bill itself, it has 20 days within the summary medical malpractice screening. Immediately following receipt of complaint involving medical malpractice in the Superior Court or District Court of Guam shall seal the case, refer the magistrate judge for pretrial screening. Within 20 days after the service of summons and complaint, the defendant shall file an answer and serve upon the plaintiffs or the attorney. So it is much faster to go through this, and time is of the essence when you're going through that. Especially when individuals, and good Senator Brown brought up the fact that it comes right here. And you can imagine losing a loved one, or even being the plaintiff yourself, where you're sick, or something devastating happened to you that you're going to have to need continuous care, and here you are trying to fight for justice. So it does become very heart-wrenching for these individuals. I mean, I'm hearing all these doctors who have an issue with this bill because they're afraid they're going to be sued. They talk about their problems, and not once have I heard them talk about the issues of the patient. It's always what's going to happen to them. But what we're trying to do is just bring that balance. Because I too have great doctors. I have a great doctor that I have to see every 3 months because of my condition. And I hope after this she still wants to see me. But she's a great doctor, and I rely on her. And I want to bring that balance on this island. The same kind of treatment that's being done in the States, why can't we have it here? It was brought up earlier about specialists coming to the island. Currently, this current law has been in the books for decades. But we can't get specialists on the island because our population cannot support those types of specialists. So what we do have are specialists that come here on a rotating basis sometimes. And I bet you those doctors have medical malpractice insurance. So for them, going back and forth because they're only here for a month, they have this coverage. I talked to a nurse who's only been on Guam for 4 years, and she says, I don't understand the big deal. I've had medical malpractice insurance from day one. Everybody has it in the States, she says. There shouldn't be an issue. Probably the first thing you get when you get out of medical school is medical malpractice insurance, just to protect you. But I think there's going to be a balance here that would be a win-win for everyone. And I'm sure that there will probably be more questions later on, and I, again, appreciate your time. I'm not going to hold you up from dinner any longer, but thank you, Madam Speaker, for the opportunity to have one last question. Thank you.
Thank you, Senator Taitakwi. And I'm going to now just make a closing statement. And so I want to thank you, Attorney Thompson, Attorney Keogh. I want to thank Mr. Paulino from Cassidy's Insurance and Mr. Takagi from Takagi's Insurance. Thank you very much for the input. Thanks for those who continue to send letters into our committee. We will post those all up on our website. We are, again, having another hearing on Wednesday, July 7th, and Monday, July 12th, both at 5 p.m. to 8:30 p.m. And so in writing this bill, as I told you, I tried to consider very seriously all the recommendations that were made and the suggestions that were made in all the prior hearings. As you know, this bill has been in place on Guam for 30 years. I even went back to the committee reports from the laws that were passed for the current mandatory medical malpractice arbitration, or current Medical Malpractice Mandatory Arbitration Act. And several testimonies were provided in support based on the belief that the legislation would benefit Guam by offering a less expensive than litigation, more efficient, more equitable, and less traumatic manner to resolve medical malpractice claims that would protect all parties. 30 years have passed since the passage of the current Mandatory Arbitration Act, and these purported benefits, I think, have been called into question. Now, we have a district court judge describing our law as manifestly unfair. Manifestly unfair to enforce the statutory requirement against a person financially incapable of arbitrating. Doing so would have the absurd result of prohibiting the poor from recovering on a claim they might be otherwise entitled to. And it would likewise shield the health industry from ever owing liability to the underprivileged. And this bill is simply meant to address that, is to address this discrepancy in our existing law that has been made glaringly apparent to all of us if we are awake. And just that. It was not meant to attack doctors or to threaten anybody, and it's really just meant to bring justice to all of the people on Guam, so that we don't have a certain class of people who are excluded from this system. Absolutely excluded. That's the findings. Those are the facts, that they are excluded. And even district court judges not involved in our politics are describing that back to us. And so I just think it's incumbent on us as senators not to look the other way when that is happening in our community, and that if we can address it, address it. And so I am very open to suggestions to improving this bill, and I very much appreciate the suggestions that I have received so far from doctors, lawyers, and of how to improve. And I am going to work very hard to make these improvements, if I can, and if I can get my colleagues' support. But, you know, there's a lot of fear and anxiety that this bill seems to have provoked in the medical community, even before the public hearings on the bill. There have been threats to further limit access to specialist care, or even before the bill's passed, to cut off care. I am trying hard to find how that is in good faith and effort to improve what we are trying to do here. Or you know, are we just going to tell these people who cannot afford to be forced into, have no other recourse if they cannot afford arbitration? That's the bottom line. They have no other recourse if they cannot afford arbitration. So we are trying to make it more affordable. And there are many ways to do that, And we will continue to look at those, but this is one way that was not going to put a huge burden on taxpayers. It's one way that was going to use an existing system that we are already paying to hopefully do that. And it's still not going to be free for those who need to avail of that system. It's still costly. And I'd like to see statistics that will show me whether, even with this bill, people were able to avail of the system. Because I have my doubts that whether we have people, with the poverty rates on Guam, whether the majority of our community are going to be able to avail themselves even of the system that I'm proposing. Because it still entails costs. It entails costs for expert witnesses. I don't think anyone's going to succeed without expert witnesses on their side describing what the standard of care is. But again, if we are keeping in the bill the standard of care that is existing today, I cannot see how these threats that we are impacting their standard of care. No, we are asking that that standard of care be continued if it is standard of care. If it is acceptable practice today under Guam law, our bill says it is acceptable practice tomorrow if this bill is passed. It does not change that at all. And I really hope that the doctors will keep an open mind. And I know that there's a lot of pressure and that there's a lot of discussion going on. And I would like to invite you to continue to engage with the senators here in these public hearings that we are going to have, and that you continue to listen as well. Because it was my takeaway from the 3 hearings that we had last term that the doctors came in good faith, a lot of them, and that they wanted a solution, and that they recognized that there was a huge disparity, and that was an injustice. And I don't think anybody wanted that when they created this law, and so we're going to fix it. And there's been a lot of pressure, I think, put on my colleagues, and so I want to thank them for their willingness to sponsor this bill. They all, told me they're going to keep their minds open and they're going to listen to all the testimony that comes in, and I expect that out of all of them, before they make a final decision. I don't know if the public is aware that we are under immense pressure from the medical community and even threats that our families might suffer lessening of medical care, that those who have high-risk conditions are going to be removed from medical care. Those who are poor, I was even told, that was one of the issues. And it's I don't know, it's blowing my mind as a senator because I'm trying to find a balance here. And there's nothing in this bill that removes this current standard of care for doctors. In fact, this bill, I think, went out of its way to find protections, to continue protections for doctors. It's very clear to me in the research across the nation that is not afforded in other states. It is not. But we are continuing to do that, but we are going to make it affordable for the patients. And I think that we can do that and continue to have doctors who are dedicated to the same patients that we are trying to be dedicated here to today, to bring them good medical care as well as access to justice, and not exclude one in order to get the other. I'm hoping that the doctors will see that the process that is in place, is one that is going to allow them to go to arbitration. Just as they are going to arbitration today, but it removes the mandate of that 3-person panel that currently exists in law. And so it allows all the parties to agree and to continue to go to arbitration just as they are doing today. It also allows a backup plan for those who cannot agree to arbitration or cannot afford arbitration, that they will, as their arbitrator, present their case to a magistrate judge, a judge of the courts of Guam. And I want to remind them that this is preliminary, before trial. But if you go to trial, you're going to be before a judge and a jury, and not doctors. So I thought that was fair, that you can bring expert witnesses before a magistrate judge and lay out every argument and example that you want to bring in to this magistrate to explain why this is standard of care on Guam. And that's how it will be done in a trial. And again, if you don't like the magistrates, you don't think they're competent enough to handle the evidence or to make this type of decision, this bill leaves open the possibility of going to arbitration instead. It still leaves that open. So again, you know, there are probably many other ways to do this. And there are many that I also considered that would just, let's let the taxpayers fund the whole thing, right? Let's keep this mandatory arbitration, but let's let the taxpayers fund it. Well, I didn't want to do that. So I actively considered that and ruled it out because I didn't think that this is a privilege that's being afforded to the medical community, that the taxpayers should bear the burden of that again. But we can allow the privilege, but I just think we can make it fair without creating that extra burden. Again, I'm open to suggestions. I've received some very constructive ones already. For example, you know, there was a lot of discussion about specialists, and in fact, you know, I was threatened that GMH could not consult with specialists on Guam because they were refusing, you know, service because of my bill. Well, I can't answer for individual doctors to what they're going to do, but I am pleading with them to please, you know, act calmly and let's look at this logically. And I am very confident that the Guam Memorial Hospital, if it needs a specialist or needs to consult a specialist, has full capability to do that, and they have done that. We see specialists at GMH who also practice in private practice, or specialists at GMH who are consulted, or specialists in GMH, as I don't know, Senator Taitagui described as long distance. They said that they really improved that process during the COVID. I remember them testifying about that in another hearing. You know, however, I'm just saying there are ways to take care of specialists. There are ways at GMH, if they are going to use a specialist, of course, to ensure that the specialists are covered under the GMH or the government of Guam's Government Claims Act. You know, we can do that. I have no problem doing that if GMH thinks they are not capable of doing that, but to my understanding, they do that already, and so they are fully capable of doing that. We're trying to change a policy where we have, I have to say, a lack of data because of the process. You know, the process keeps it closed. We can't see the results. We can hardly, you know, we have to call up these lawyers and ask them, how many cases have you done in order, you know, to gather this type of information, because we can't get firm data on that. Even the insurance companies can't get firm data on how many claims are being made by, you know, all around. They can't get firm datas on what the settlements were. And so, you know, some of this, it's not a perfect way to make policy, but, you know, I want to assure the community that we are leaving no stone unturned, that we are trying our best to look at everything and come to some policy that is going to be fair to all. And that we continue to be open to suggestions and solutions. And when this bill was introduced, it was the only solution introduced. It was in the absence of any other solution being introduced and in the face of our law being criticized as draconian and unfair. And in the face of testimony from patients saying they were unable to access justice. So again, I want to thank my colleagues and thank all of you, and thank those who are listening, and encourage us all to just work together to come to a solution on this. And we are going to continue with public hearings on July 7, 2021, Wednesday, and on Monday, July 12, 2021, from 5 p.m. to 8:30. I encourage all of those who are interested in this process to contact my office so we can sign you up to testify. And because we're going to be trying to manage in person and in Zoom, if you could please contact my office in advance, that would be very helpful for us to be able to ensure that your participation is coordinated. Again, there being no additional individuals to present testimony, this informational hearing is now adjourned, and the time is 8:08 p.m. Thank you.